Yeah. Yeah, good morning, Mr. Steve. Thanks for having me. By the way, please, I have finished the message with manager for terms and disconnected. Okay, okay. So I'll just have to go to now the system. That's all. Okay. Hello, good morning, Mr. Steve.
Good morning, sir.
Can you hear me?
Loud and clear, sir.
Hello.
Can you hear me?
Yes, I can hear you. Yes, I can hear you. Can you hear me?
I can hear you, Mr. Victor. Can you hear me?
Yes, I can hear you loud and clear.
Okay. So I guess wait, Mr. Vincent is calling me. Hello, Mr. Vincent.
Yeah, I spoke. You didn't respond. I don't know what.
I have been responding. Mr. Victor can hear me. Mr. Victor one. I've spoken to him. He can hear me on the call. So you are the one who cannot hear us. Check that your audio.
I have unmuted. Maybe I have to restart the system.
No, the speakers. The speakers is what you need to check.
Okay.
You need to check the speakers. Mr. Victor heard you. I heard you. Maybe your speaker is disconnected. Can you hear me?
Can you hear me?
I can hear you. I can hear you, sir.
I can't hear you. Let me check again. Can you hear me?
Loud and clear.
I can't hear you.
So it's your speaker. Let's go to the computer. To the computer, go to the bottom right-hand corner of your screen. Are you there?
Yeah, that is on speaker. There's an arrow. I click on it.
Yes. So what does it show as your speaker? What is selected?
The one that is still is the same as system HP 11.
No, I'm not talking of Zoom. I'm talking of your Windows environment. Bottom right-hand corner, the status bar.
Okay. You don't even know there. I opened the bottom visa. All are working now. And they are connected here. So let me look at another book. I click on scan. There's no much there.
But I can hear you very loudly. I can hear you very, very clearly. It's all right.
Hello, can you hear me?
I can hear you, Mr.
Yes.
Vincent. Can you hear us, Mr. Vincent?
Hello.
Hello, Mr. Vincent. I can hear you loud and clear. The problem is with your speakers in that place. Somebody must have disconnected something. The problem is with your speaker. All of us online can hear you very loud and clear. You are the one who cannot hear us. So the speaker has a problem. Check all the connections for the speakers. Somebody must have disconnected something. Are you sure the speakers are switched on?
Yeah, they are switched on.
Maybe cleaners have in doing their work have disconnected something.
Very.
I can hear you, Mr. Vincent. I can hear you in the courtroom, and I can hear you also on this call.
Okay.
Can you hear me in the courtroom?
No, I can't hear you. Did you touch No, I want to anytime you want see be I want to post. You know, the do I mean you look in the environment will force it. So, only when then. Adams, please call Jonathan for me. Maurice. Adam, come, I don't getting old to there. I can get on like so most of them but even most of them get a massive fight competitor. Kò sẹ́ni tó lè rí àárín àwọn méjèèjì àpótí ẹwọ ẹfí ẹwọ. Ohun tó bá ti rí létí mọ́ ohun tó jọ òun kí wọ́n bẹ̀rù kó ń bẹ̀rù. Kò sí ọ̀nà kí wọ́n bẹ̀rù kó ń bẹ̀rù. I am respecting you.
Huh? Are they coming down? Hello, can you hear us?
I can hear you.
So a meeting, most everybody ní iṣẹ́ yẹn wọ́n ti believe pé before kí o tó sọ̀rọ̀ wọn tààrẹ ti yọyọ wọn ti yọ pa wọn ti yọ kún tó fi sí ìfọ̀ tí wọn bá fẹ́ sọ sí. Ṣé mọ̀ tó ṣẹlẹ̀ ní sẹ́ńtì? I interview ẹ̀.
It's Tosin you will call. It's not Fatai. Fatai has nothing to do with this.
Mo interview ẹ̀.
Yes.
Ṣé mọ̀ pé ọmọ láti pè wọ́n lẹ́yìn pé kó máa èmi wá pè. Báwo ni wàá ṣe máa give ọ̀sẹ̀ tẹ́kọ̀ọ́ ní ìgbésẹ̀ I hate you. Hello. And you want message if you don't want to go out there, we have some messages now. For the modern side.
Yes, the whole truth is not. We are talking
with your bedtime. You don't want it.
We are talking. We are telling us errors. I call it God right.
And now.
See one thing. So whether if you have a start, I will restart the system. It's not existing.
We can't hear them.
We can't hear them. They can't hear us. Hello, good morning, Mr. Tosin. My name is Justin. I'm calling from.
Eventually, what she not
We have it this morning. We are having issue with the audio. The people on the other side, they can hear us, but we can't hear them when they talk. Even I can't even hear Siri, but still they can hear us.
Let them talk.
From the TV set?
Let them talk.
Yes.
Wow.
We did a sitting yesterday and everything was okay before I was shut down. Okay. Let me call you on the power.
Let them talk. Ask Mr. Stephen.
He's hearing if as you talk, he's hearing you. Mr. Stephen, can you hear us?
I can hear you. Can you hear me? I can hear you.
Please call any of your person or just say you can hear us. Let the person unmute any of your person that is there. None of your person. Okay, the phone here. Let me call the noisy one if you can. But I don't turn
Mr. Victor. Emeka.
Hello, I can hear you.
Mr. Lovely.
I can hear you. Hello, can you hear me? Hello? Can you hear me? Hello? Can you hear me? Can you hear me? Yes, I can hear you now. I can hear you. Can you hear me? Can you hear me? Can you hear me?
I can hear you, Mr. Nemeka.
Okay,
It's
thank
them.
you.
Them cannot hear us. Something is wrong with the speakers in the court. Apologies for this, please. We're trying to figure it out.
Okay.
Thank you very much.
Really, okay, you saw the email we sent. Can you see? Victor, can you hear?
I can hear you.
Yeah.
I can hear you. Can you hear me? I can hear you.
This one.
Yes. I can hear you. Can you hear me?
Yes.
So this is the first day for the next something.
Okay. It's 100% now.
Okay. Stand by on this drink. Maybe it's just Stevie.
Yes. Stevie,
Mr. Stevie.
Mr. Stevie. I couldn't know. Okay. Yeah, somebody has muted one of the participants. So what do you want now?
I want them to talk.
Mr. Victor, can you hear us, Mr. Victor?
I can hear you. Can you hear me?
I hear us. Okay, yeah, John, please, John, if you can hear us.
Okay. That's how much that's
Okay.
But you do have to be ethical in police business. So it's basically clean out that.
That's really. It's bad.
hold on, sir. Just hold on.
Okay. Hello? Hello? Please,
Sorry, I was not really so disgusted. Okay, this whatever. Okay, see, go to what is now talking about the system of us. See that is where so this is that is our that it might like one.
Yes.
What's it?
Yeah, there are people.
Surely, yeah.
There's no error code showing you. No, look, I was trying to troubleshoot the sound system. So that is the dialog board that came out.
Sound system. Laptop is a sound system.
Okay, you can look at it.
Sound system.
Okay.
Okay. That pass. Record to the other side.
Which side? Okay, here.
Yes.
Okay.
Yes. Yes.
Okay.
It's an assist.
Number one, I have the same as system that under selected microphone. Then next one we have three headings. One is a select the microphone, the other one is select the speaker. Okay.
Now, let's go to my this speaker.
Okay.
Yeah. So that's the second one.
Okay. I've deleted it.
Yes. So let's already see something.
Mr. Victor.
Mr. Victor,
Yes.
can you?
I can hear you. I can hear you. Can you hear me?
I can hear you.
We can hear you.
I can hear you. Can you hear me?
No, they cannot hear you, Mr. Victor.
Oh, they cannot hear me.
No, they can't hear you.
I can hear everything.
Thank
You
you
say
very much,
something.
Madam Cynthia. Thank you very much. But we're having some technical issues that we're trying to sort out. So please bear with us.
Okay. I've done that.
All right, please.
Let's take the Sorry, gentlemen, we have a technical issue with the audio system here. So let's take the reading first. Let's see what can be improved. Go ahead.
Number 3 on the cost list is appeal number TAT/SSS/002/2022 by Israel State Board of Internal Revenue versus Continental Oil and Gas Limited.
Why already wrong? The number 3.
Number 3 on the cost list is appeal number TAT/SSS/032/2023. Pellegrini Nigeria Catering Limited versus Aqua of State Internal Revenue Service.
Very respect to the tribunal. My name is Nuruddin Aziz. I told my friend, okay, Cynthia, which is 7. So the group and another appearance from that.
The volumes. Party representatives.
No. Yeah.
Already. But in defense of this appeal, the respondent opened his case on the 14th of October 2025 when he called his witness, Mr. Lawrence Ekudo. The witness testified and tendered 7 documents as exhibits for the respondent and was partly cross-examined by the appellant. The case was adjourned for continuation of examination the 7th of November 2025. The case suffered 3 adjournments because the respondent's witness was no longer available for the examination to be concluded and for the case to proceed. On the 20th February 2026, counsel to the respondent, CNS Ibe Basi, during the virtual hearing, informed the tribunal that he had an application which was filed on the 16th February 2022. The application was seeking for leave to be granted the respondent to amend its list of witnesses, to file additional list of witnesses, and to deem the witness statement on oath of one Mr. Eseme Okore filed on the 16th February 2026 as having been properly filed and served. The application was not opposed by the appellant and was granted at grade. Counsel to the respondent then applied to the tribunal orally that the evidence of Mr. Lawrence Ekudo be expunged from the records of the tribunal. The appellant opposed the application of the respondent, and the tribunal ordered the parties to file their respective addresses for and against the application to have the evidence of Lawrence Ekudo expunged from the records of the tribunal. On 17th April 2026, both parties adopted their written submissions, and the case was adjourned to the 21st of May 2026 for ruling. However, counsel to the respondent wrote a letter requesting for an adjournment, and the case was further adjourned for ruling and continuation to the 18th day of June 2026. Submission of the parties. The respondent submitted that its witness, Mr. Lawrence Ekudo, was redeployed to another directorate of the respondent, and all efforts to get him to attend the tribunal to conclude the cross-examination proved abortive. The respondent submitted that the fundamental principle is that evidence which is not subject to cross-examination is usually considered to be hearsay or incomplete, and cited the case of Okweke against the state, 2021, 1 Nigeria Weekly Law Report, part 1758 at page 570, where the Supreme Court stated that the object of examination in chief is to elicit from the witness all facts to prove the case of the party calling. The object of examination is to weaken the adversary's case. It is designed to find out the truth. The object of re-examination is for the witness to clear all doubts by the explanation of all material facts referred in cross-examination. The respondent submitted further that the purpose of ensuring that a witness undergoes all the 3 stages of examination is to give fair hearing to the other party, as guaranteed under Section 36 of the 1999 Constitution of Nigeria. The respondent also referred to the case of Juvenile Group against the state, 2022, 4 Nigeria Weekly Law Report, part 1820, page 371, at pages 390 to 391, paragraphs B to A. The respondent urged the tribunal to expunge the evidence of Mr. Lawrence because he is no longer available for examination and possible re-examination. The appellant. The issue for resolution is whether the application of the respondent to expunge the evidence of Mr. Lawrence, if granted, will not amount to a violation of the appellant's right to fair hearing, and whether it is not proper to retain the evidence till conclusion of the proceedings, when the evidential value of the testimony of the witness can be considered. It is a submission of the appellant that once a witness has taken oath, given evidence in chief, and has been partially cross-examined, the evidence forms part of the tribunal records and cannot be expunged. The appellant is of the view that the respondent failed to produce the witness before the tribunal and should not be allowed to benefit from his own wrongdoing or default. The appellant submitted that the two cases of Okweke and the State Supra and Junaidu and the State Supra cited by the respondent relate to criminal cases and are inapplicable to the present civil case. The appellant referred the tribunal to the case of Adegoke Motors Limited against Adesanya, 3 Nigeria Weekly Law Report, part 109, 250 and 275, where the court held that it is not helpful to rely on authorities without regard to the facts and circumstances of the peculiar case. Each case must be decided with its peculiar facts. Also, the appellant relied on the case of Skybank and EU 2017-16 Nigeria Weekly Law Report, part 1590 and page 24, where the Supreme Court held that the decision of the court must always be understood in the light of the facts which give rise to it. The appellant also submitted that the Supreme Court in the Punji and in Jokama 1999 12 Supreme Court of Nigeria, at page 259, held that cross-examination is a vital instrument for testing the credibility of the witness. But the absence or incompleteness of cross-examination does not automatically render evidence admissible. In its final submission, the appellant urged the tribunal to dismiss the application of the respondent to have the evidence of Lawrence to be expunged from the records of the trial. The tribunal is of the view that the simple, direct, and straightforward issue to be determined here is whether evidence of a witness given in examination in chief and who is partly cross-examined, but is no longer available to complete the cross-examination and possible re-examination, can and should be expunged from the records of the tribunal. The issue here has nothing to do with the importance or essence of cross-examination and the effect of failure to cross-examine a witness on a material fact. The law is quite settled on these issues. All the judicial authorities cited by the parties in their arguments for and against, in the present instance, deal with one or all of the situations above. It is, however, interesting that the cost of this oral submission adopting its written address, opposing the application, counsel to the appellant cited the Supreme Court case of Ojo and Daloro, 2006. 10 Nigeria Weekly Law Report, part 987 at page 173, to the effect that the Supreme Court held that quotes, evidence given on boats before a court remains part of the records and can't be withdrawn by the whims of the party. It only goes to the stewards attached to it on boat. We have painstakingly read through the lead judgment of the Supreme Court delivered by the erudite Likitomi JSC, God rest his soul, but have not found anything close or related to what counsel to the appellant cited the Honorable Tribunal. That is whether or not the evidence can be expunged from the records of the trial. As earlier stated in this ruling, the issue is whether evidence of the witness who testified and was cross-examined can be expunged because the witness is no longer available to complete the cross-examination and has been replaced by another witness. The Court of Appeal in the case of Olomo and the State, 2014, the LPELR at 22517, Court of Appeal held as follows. Quote, as I stated earlier, the PW2 did not complete its examination. It was also not cross-examined. In other words, the PW2 abandoned his testimony. The law is that the evidence of a witness who abandons his testimony has no evidential value. Such evidence is irrelevant and of no evidential value and should be discountenanced by the court in the assessment and evaluation of evidence. And they rely on the case of Yusuf against Obasanjo, 2005, 18 Nigerian Weekly Law Report, part 956, page 96 at 132, paragraph H, and pages 216 to 217, paragraphs H to A. In the circumstances, the entire testimony of PW2, including the material SDB standard by him, have no evidential value and therefore go to no issue. P. Haruna Simon Samani, KCA, pages 29 to 29, paragraphs E to N. Unquote. Similarly, in the case of Sumoga against the state, 2015 LPDLR, page 24534, the Court of Appeal held that, quote, it has been held that evidence of a witness who was presented for examination or whose evidence was untested under cross-examination by the failure to put him for examination after his evidence in chief has no probative value. Via the cases of Shofola against the state 2013, page 281 at 320 to 321, pay the judgment of Audi COA. Al-Mustafa against the states, 2013, 17 Nigeria Weekly Report, part 1383, at page 350 at 423 to 424. The judgment of RDHSA, following the case of Isiaka and the states, 2011, all FWLR, part 583, page 1966. And a fairly recent Supreme Court case of Ikar and the states, 2014, one Nigeria Weekly Reports, part 1389, page 639 and 652, paragraph A. The Joseph Chagwa Ikia, JCA, at pages 23 to 24, paragraphs E to G. In a very recent case of Adebayo against the state of agency, 2026, LDE page 83141, Court of Appeal. The Court of Appeal restated and confirmed that the law is that the evidence in chief of a witness who is not produced for examination cannot be acted upon by the court. The Mohammed Lawal Sher, LCA, pages 68 to 68, paragraph B. Counsel to the appellant has made a submission to the effect that legal principle elicited from decisions in criminal cases do not apply to civil cases. This is quite a novel submission. The same evidence as applies to both criminal and civil proceedings. It is the only guide when considering the evidential value of any evidence or document before the court. In the case of Olomo and the State Supreme, the Court of Appeal referred to and relied on the decision in the civil case of Yusuf against the passenger of Supreme. If the decision of a court in a civil case can be referred to and relied on by the Court of Appeal in the criminal case, we think that decisions in criminal cases can also be referred to and relied on in civil proceedings in appropriate circumstances. The current legal position from the three cases referred to earlier is the evidence in chief of a witness who is not available for examination, has no evidential value, and cannot be acted upon by the court. The respondent's witness, Mr. Lawrence Tugudo, had given his evidence in chief, but is no longer available for his presentation to be completed. He said Tugudo can be said to have either abandoned his testimony or has failed to put himself for presentation after his examination in chief. His earlier testimony or evidence, therefore, has no evidential value. What is the essence of crowding the records of the tribunal? The evidence of a witness who is no longer available to continue with his presentation and which evidence has no evidential value. It does not make any legal sense, as the evidence has no more evidential value in the proceedings. In view of the foregoing consideration by this tribunal, the opposition of the appellant to the application of the respondent to have the evidence of Mr. Lawrence Tugudo expunged from the records of the tribunal fails and is refused and rejected. The respondent's application succeeds and it is hereby granted. The evidence in chief of Lawrence Tugudo and his evidence under presentation in respect of this appeal is expunged from the tribunal records accordingly. This is the tribunal.
Tribunal places. On the platform.
As the tribunal places.
Yes,
so it was adjourned for ruling and continuation of
yes,
defense.
but of course they are not here.
So let's take it down.
We are most grateful for the utmost support.
Yes.
The matter was supposed to proceed this morning, however, the respondents are in court. Neither is their witness or before the trial. So, no reason was also provided as to the reason why they are not before the tribunal this morning.
Yes.
Appellant has also extended money for appearing before the tribunal. But this one will be asking for the cost of 2 million. The tribunal will agree with me that this matter has suffered over 5 adjournments at the respondent instance. Has suffered over 5 adjournments at the respondent instance. Right from the time they refused to present Mr. Lawrence. To complete his cross-examination. But most of them.
With this, I think you left.
After the last agenda, I think it's
What is that?
You text me the job started. Says you want having this you know to you to start and you need it. They go to the and forget this is intent. So what was the I just went to the life was
Is it up to 5 times? The adjournment.
No, the last one was before you brought in actually adjournment. When we told them to bring Mr. Lawrence, and we couldn't bring Mr. Lawrence, and between that time and that, it's about two adjournments. Okay. Yes, we awarded 100,000 past, but they are yet.
You did ask for it,
You did. So they asked us to send the account of the company to accept that.
When was this account message?
We send it the way they are not going to send it to us, they are going to send it to them. So we just want to confirm this other. Whenever you want to make it. But it's subject to the discussion of the tribunal.
If they pay to the company, dinner.
No, of course we don't.
Programmation of it would have started on the 14th of October. Seventeen. The 7th of November, we're not there. They cannot use the
But we're still not here.
Okay, I don't the 6th of December. Not December, okay. Oh, so. Everyone's didn't show up. So that was on the 7th of November. That's after I had it was a polling on the 20th of March. This was the plan for 17th of April. University Progress Fund. Okay, police.
Since that letter, almost yesterday, the secretary have tried working.
What they say, also is that
What translation?
Maybe of some of those. Maybe of original.
you know, the history of not get crossed. The circumstances of this case and this are different.
All right.
The way the panel resources are different. We are what we call
Still subjected.
you are thinking that we feel like.
For them substance.
So that I don't digress.
All right. I'm sorry.
It's understandable that yes, we are pure cost.
But I think it's serious, was real. I mean, I used to.
Do you talk with the council?
So, no, ordinary, even the last time they sent us in they sent a letter
It's for preservation. Yes, sir.
I think this one will not examine the new witnesses for examination of
On the fence. The tribunal is inclined to avoid all circumstances and has indulged the respondent once more. This case is further adjourned to July 2026 for defense.
and most of them.
Oh, what is that? This thing is echoing here. Yeah, because we have to go. When we don't check on the rest, you will be here. So that you can be hearing. The challenge we have to connection from the connection from this process. So call the next question. That's on the moment.
Number one of the first
Next. Or let me think of it.
Number one on the course which we are paying number TAT/SS/008/2025. Bayelsa State Board of Internal Revenue versus Lordship Supermarket. With utmost respect, Mr. Chairman and honorable members. My name is I.M. Jenen. I'm here for the appellate.
With humility, my lord. N.V. Ngong appears in protest for the ostensible respondent.
Me.
Yes. Yeah, but I don't for. You see. I asked this question before. Did you look at the of this surveillance? In the regular state?
Yes, I have, yes.
You got it.
Yes.
You still want to. Go on with the motion.
Yes. The facts are different.
Are you ready?
Yes, subject to the convenience of the tribunal.
He wants to go on. Let me go on.
Mr. Chairman, before this tribunal. So motion on motions. Dated the 25th day of March 2026. And file was sampled. 25th of March 2026. From the 26th. 2026.
Oh, right.
The 25th. 25.
Motion. Just in the question. Yes.
Motion, the prayer stop as contained on face of the motion paper. Supporting our motion, the 14 paragraph affidavit. We attach one exhibit. In compliance with the rules. This is the substance. 14 paragraph, 14 affidavit. Yes, it is posed by me.
The 15 paragraph.
14 paragraphs. And we attach one of the.
Yes.
In compliance rules of this tribunal, we file a written address as our argument in support of this motion. We have our adopted to support. The facts supposed to use the affidavit.
No? You said?
So we adopt our written address.
Yes. After that, you say something.
In support of the facts, we supposed to the affidavit.
Yes.
Upon receipt of the respondent counter affidavit dated the 14th day of
The 10th.
Sunday.
14th. Let's see.
Upon receipt of the respondent counter affidavit for our motion, we file a reply of Johnson to me.
That's what they wanted to do.
Let us speak
So was that come? What of November? Is that the one?
The one for November or the one for?
No, it's not November.
7 days. 7 papers.
on his foot, 7 minutes.
There's one for 70 minutes. I think it's that one. That is the current one.
It's not so the phone is not back with the waiting. We try to the last of this one. Various.
It's 25th of March.
So you arrest the way.
It's 25th of March.
The 7th of,
Not 5 and 7.
yeah.
No, 25th of March. That's the one I have.
The
Arrest the
your
ruling.
match is your honor.
Where is the owners? To arrest the ruling is theirs. Counter. Theirs was 5.
On the 7th of days.
Now you are reading the. It's dated. Okay. Yeah, thank you. It's 7th of.
You file your application on the.
I'm very sorry, 7th of May.
You file your application on the 25th of March. So they file a count on the
Yes,
7th
please.
of May.
The tribunal is like 7th of May. So on receipt of the respondent.
On the.
He can hear.
Yes,
sir.
I can.
So upon receipt of the respondent counter affidavit, the father reply on points of law. On the 20th of May, 2026. To support of our motion. Yes, sir. 2026. That was your reply on points of law. Yes, reply on it.
Yeah.
We adopt it. As our further argument to support of our motion. We urge this tribunal to grant our application in the interest of justice. We are so glad.
Stick to with the question. You can talk to it.
Yes, order.
Yes, my lord.
Look at your colleague.
My lord, we earlier indicated that the motion is dead on arrival and ought not to be considered at all.
That was earlier. But now.
Yes, my lord, we are maintaining that position and we have articulated the argument in support of the position by way of counter affidavit and written address. In opposition to the purported application.
Yes.
My lord, the counter affidavit was filed on the 7th day of May, 2026. It is only a 5-paragraph affidavit. Which exhaustively articulated the issues of law. Raised by the purported motion. My Lord, we adopt the said counter affidavit and we rely on the said counter affidavit and adopt the written address in support thereto. For the purpose earlier on indicated. We are also in receipt of the purported reply.
What is it purported?
It's purported, my Lord, because it's misfounded. It's misconceived in law. It does not answer to the issues.
Yes.
My Lord, on the said reply, the said appellant purported to have answered to the issue of the argument on the status of the appeal as an abuse of court process. By stating in paragraph 2 of the said reply that the issue of abuse is an argument of counsel without evidence.
The issue of abuse is what?
That the issue of abuse is an argument of counsel that is unsupported by evidence. And the further said,
Sorry, one more.
my Lord, the argument in paragraph 2 is to the effect that the position or argument of the ostensible respondents counsel in respect of the appeal in itself being an abuse of court process was an argument of counsel and that it is not supported by evidence, and went further to state the law that the argument of counsel can never take the place of evidence.
Yes.
In rebuttal, my lord, we refer the Honorable Tribunal to paragraph 4.w, paragraph 4, subparagraph 4w of the counter affidavit. Deposed to
Paragraph 4.
subparagraph W, 4W. W as in West. Where the deponent, other than the counsel, gave flesh to the fact which was argued by counsel in the address. My lord, there is also no law in our body of jurisprudence that even prohibits a lawyer from giving evidence, assuming I'm even the deponent to that affidavit. There is no law prohibiting a counsel from giving evidence. In this case, we have not even given evidence. The facts belongs to the parties, the law belongs to the lawyers. The party has supplied that fact, and we have laced it with the law, which is our job. And they turned around to say that the argument is unsupported by evidence. My lord, we have showed copiously the support to that argument. In paragraph 3, another misconception about the powers of the tribunal to grant amendment arose.
Then we came to litigation.
That is the point. That is the more reason why this would have been struck out. I'm on my feet.
Mr. Chairman, I'm coming. I'm objecting to the pattern. This is a rowdy situation. We file a reply. He's replying to our reply with facts. Is it proper?
Can you please just address the question?
Okay, no problem.
My lord, it is apparent with the greatest respect that my learned friend does not know the practice and procedures of any court in Nigeria, obviously.
He's sitting down. He's sitting down. He cannot say it on his feet. He should say, I am sitting down.
My lord, I'm on my feet.
Sit in your house, in your private room, and you say you are on your feet. Are you on your feet?
My lord, I am on my feet. Let him prove the contrary.
Stand up, let's see you. You cannot say you're sitting down, you say you're on your feet.
My lord, I am on my feet.
You're sitting down.
I am on my feet.
It's all right. As the tribunal pleases.
We address a question to one.
We just ask
One.
Yes, my lord.
All this is referring. I didn't know you addressed.
My lord, these are fresh issues that arose from reply.
So
they were
can
not
you address
after I have filed my counter, they said they are replying me. They are now putting in fresh issues of law. And in law, I am entitled to respond.
Now, can you respond to issues of facts?
My lord, I'm not responding to fact. I'm responding to law. I have no right to respond to facts. I rather have the right to respond to law.
He's going to his counter.
The areas you are referring to. Can you allow us with this? You are referring us to the positions in affidavits.
My lord, he said the argument is not supported by evidence. It is my job to draw the attention of the tribunal to where it is supported. If I keep quiet, I've considered to that point.
Why did you file a affidavit?
My lord.
Why did you file a further affidavit?
In response.
Sorry, sir.
Why didn't you file a further affidavit?
My lord, I have the right to respond to them orally, except my lord the right otherwise.
No, you're responding without an affidavit. You cite law, not facts.
My lord, I'm not citing facts. I'm talking law. I'm saying, he said we did not say this, that it is argument of counsel. We refer the court to paragraph of affidavit that supports the argument that was made that it is not a fact supplied by counsel. It is rather supported by evidence. How would the tribunal have known if I didn't draw the attention of the tribunal to it?
That's right. You are giving us facts.
I'm not giving facts, my lord. It's law. The issue of law that I'm responding to is whether the argument of abuse is supported by evidence.
Which law? Which law is that?
My lord, the point I've made is that one, there is no prohibition in our law that says the council cannot give evidence, assuming without conceding that I am the one who brought that fact in. So I've made that point.
What's the authority?
Well, I can give you so many. I can give the tribunal so many of it. I can in a few minutes. I will give the tribunal so many.
Can you give us an authority?
My lord, that is not even the issue now. I'm saying that circumstance does not even exist in this case, but they have made it to look as if it exists.
Why are you wasting our time? Go on.
I'm not wasting the time of the tribunal. I'm drawing the attention of the tribunal to specific facts. Now, in paragraph 3 that I was addressing, my lord, they made.
Wait now. Oh, no. Now you accept that you are referring us to facts.
Not law.
It is not so, my lord. The issue of law raised is whether council can raise issues that are unsupported or address law that is unsupported by evidence.
Yes.
In showing here that council did not do what they alleged, the attention of the...
Go on with your further submission.
Thank you, my lord. Now, the issue of the powers of the tribunal to grant amendment.
You can't take all the time. 10 more minutes.
As a couple places. Now, on the jurisdiction of the tribunal to amend processes, my lord, we submit that we are not in doubt of the powers of the tribunal to grant amendment or to regulate its own proceedings.
Might take that again.
My lord, we say we are not in doubt of the jurisdiction of the tribunal to grant amendment or to regulate its own proceedings.
Mr. Chairman, I still maintain this procedure is citing law. This procedure is wrong. What he is doing is trying to lecture the tribunal. It's an academic exercise. Trying to lecture the tribunal on the powers of the tribunal. You're trying to repeat the rules of this tribunal. It's not proper. It's proper. We file a reply on points of law. If you feel you want to say one or two things, you file a further affidavit. You never did that. And the tribunal called his attention.
Ben, he has made a submission. Do you know whether he wants to back it up?
For this procedure, it still is.
You know he wants to back it up.
I know even when you want to.
I love this man.
You
make
based on certain facts.
Yes.
You introduce those facts
and then you bring the authority. Somebody decides.
He was not the person that filed the reply.
You say we are not in doubt of.
It is only in his character that he can do that. That he will lead facts and supply the authority. At this stage, he cannot do that.
We are not in doubt of
he cannot
amend or regulate his own proceedings. So what is
this? Is overreaching.
Is that?
It is. It's overreaching.
You should have put that in an affidavit.
He's saying it now. It's overreaching.
Yeah.
Now, if I choose to reply, there will not be an end to litigation.
What will you reply?
And there are submissions here.
Don't you have a right to reply?
At this stage, on a reply on points of law.
Wait, you move your.
Well, I'm going to leave it at the discretion of the tribunal. For me, I feel this is overreaching.
I hope you will to listen for a while. You made this. You moved your application. Did you move your application?
Yes, and I moved a reply on points of law to further our argument.
Wait.
Of course, we have a right to do that.
Listen, you move your application.
What he's doing now
Can
is
you
going
listen
to
to me?
file a counter. He lead with an authority, a fact, an authority.
Wait.
I'll drive not
Don't let us.
I'll drive not business.
Can you listen to us? You don't want to listen to us.
I'm listening, sir. I'm very sorry. I apologize. I'm only saying that the procedure is not right.
You move your application. Did you move your application?
I did.
He is responding to your motion. Does he not have a right to respond?
He's referring to our
Wait,
facts
I'm asking
and
you.
points of law.
Wait, does he have a right to respond to your motion?
Reply on points of law.
Is he, does
He's referring to our reply on
he
points
filed
of
a
law.
counter affidavit?
He's not referring to the counter, he's referring to our reply.
Very well.
He's simply the counter, his response.
Answer the question I'm asking. Does he have a right to respond to the motion?
Fishy has done that.
Has he finished? Has he told you that he
He may
has finished?
have an authority.
As a driver.
Has he told you that he has finished?
So let's.
Now, at the end of the submission, don't you have a right to retry?
No, I don't need to.
Don't you have a right?
No, I don't need to. I don't have any right.
I'm not
Because
asking-
if I continue, you want to respond again.
See, I expect you to come.
No, if I continue to respond, you will want to respond again.
If you are not ugly,
Besides this tribunal, what of you have an application outside?
I wouldn't know.
Because I think.
I hope you was able to.
Just advise yourself.
If you don't listen to us,
Because we're making this place getting around.
go on.
Thank you, Honorable Tribunal.
Respond, you're here before.
I'm saying that the ostensible respondent appreciates the powers of the tribunal to regulate its proceedings and to grant amendment. However, that is not without limits in law.
Yes.
And that limit raises the issue of jurisdiction.
That is what.
That limit is that the court can only do amendment where it has jurisdiction. Therefore, where the court or the tribunal does not have jurisdiction to entertain the matter as it is at the stage of any application, the tribunal also lacks the jurisdiction to entertain the application.
Not in your submission. Where's me?
My lord, it is not there. There are silent issues they raise. Those what I'm replying. I'm not restating my case. My lord, in Chikodere and the others against Ifeanyi and others, 2022,
Now
Chikodere and others.
It's not contained in his argument. In paragraph 4. He said determination of jurisdiction of the court. He said so. He said so. Determination of jurisdiction of the court. And we responded to it in our reply on points of law. He said so there.
You are jumping up and down. You are jumping up and down. Why not you sit down for us to conduct this process? Why not you respect yourself and sit down?
What's the name of the authority you cited?
My lord, Chikodere and others
What?
Chikodile and others against Ifeanyi and others 2022 LPELR 58267 58267.
Are we communicating?
Sorry, my lord. Sorry, my lord. I can hear.
Chikodri or Chikodri.
Okay, I should spell. Sorry. Chikodri is CHIKAODILI. Chikaodile. That is, my lord, that is how it is pronounced in Igbo language. The A is silent. I had to bring it out for the purpose of those who are not Igbos. The A is silent in the pronunciation. And others against Ifeanyi. Ifeanyi is IFEANYI. And others reported in 2022 LPELR 582 C7CA C7 Court of Appeal. My lord, 58267 58267CA.
Yes.
My lord, in that case, the Court of Appeal made it abundantly clear that issue of jurisdiction is not equitable. It is statutory. And a party cannot be endorsed under quote of substantial justice where he is in default or in defiance of a requirement of jurisdiction. My lord gave me 10 minutes and Bembem took the whole 10 minutes.
Round up your submission.
My lord, the case of Green and Green was showed up like every other case that were cited in the reply. None of them has bearing to the discussion in issue. They are copy and paste authorities. Green and Green decided proper parties. It did not decide amendment. I've read it even this morning to see if I can find amendment in Green and Green. It did not decide it. My lord, in summary, the point on Fontis Officio is very germane to this proceeding. This tribunal, in its earlier ruling, had found that the name assumed, Lozi Supermarket, does not exist. That's the finding of the tribunal. The tribunal is bound by that decision. And every other application brought to change a party for a non-existent party is in defense of the clearly cited Supreme Court authorities, which says that no party can be allowed to substitute an existing with a non-existing party.
Yes. That's a summary, so conclude.
So in summary, finally, my lord, this application is to arrest the ruling of the Honorable Tribunal. And we have cited several authorities to point out that it is not allowed under our jurisprudence. The ruling that is reserved on the PO, the ruling that is reserved on the preliminary objection, once a matter is reserved for ruling, nothing can stop that ruling from being delivered. The tribunal cannot take any other proceedings to defeat its own ruling, especially in this case where the tribunal asked the parties clearly, are you minded to go on with this preliminary objection? And all parties concurred. We have cited both Supreme Court and Court of Appeal decisions that says that right to fair hearing is not without limit. And that where a party has been given the opportunity to be heard and he waives it, he cannot turn around and begin to bring applications for the same thing. So in the circumstance, we urge the Honorable Tribunal to dismiss the application with substantive, in fact, strike it out because he has no jurisdiction to hear it in the first place. The Tribunal has no jurisdiction to even entertain it. That is the decisions we have cited. We so submit.
July for ruling.
As the tribunal pleases.
By consent of both parties, this case is adjourned to the 17th July 2026 for ruling.
At tribunal please.
Number 2 on the Court of Appeal number T80/SZS/2. Let's take what I mean, Mr. Oil Glass Limited.
With utmost respect, Mr. Chairman, honorable members, my name is I.M. Benbe. I am here for the appellant.
Any respondent? Jonathan, are you honest?
I'm not here.
I see a lady there.
I'm in this.
There's somebody there.
May I please this Honorable Tribunal? I'm Henrietta Bayogo. Henrietta Bayogo. Bayogo is spelled Benyeogor. For the respondent.
Come again, please.
Benyeogor. For the respondent.
Benyeogor, Yes. Yes.
Honorable Chairman, we have a motion for stay of proceedings.
Any party?
New.
Yes,
We have a motion for stay of proceedings. Our motion is dated the 24th day of April 2026. 24th day of April 2026.
That's not gonna shoot. It's a reason for sale. The bottom. Let's see the contact with which one's if there is a clear Yes.
Yes, Mr. Chairman. Our motion is seeking an order of this Honorable Tribunal staying further proceedings in this appeal, pending the hearing and the determination of the applicant's appeal against the ruling of this Honorable Tribunal delivered on the 16th of April 2026.
Yes.
In support of our motion, we have filed a 6-paragraph affidavit. And we have also, in compliance with the rules, we have also filed a written address in support of our motion. Mr. Chairman, we rely on all the arguments in our written address and the exhibit tendered in the affidavit. And we pray that this Honorable Tribunal grant our motion as prayed.
Director, that's all.
Yes. Yeah, in addition, we also filed a further affidavit in support of the motion.
Yes.
The further affidavit is dated the 17th day of June, 2026.
What is?
17th of June. 17th of June, 2026.
Yes.
We exhibited two affidavits. One, the affidavit of compliance and the record of proceedings, showing that this matter has been appealed. We also filed, and also the notice for transmission of the records of appeal, and the acknowledgement page of the appellant's brief of argument.
Yep.
That's all.
Mr. Chairman, in opposition, the counter motion filed by the respondent. The appellant filed a counter affidavit by 24 paragraph counter affidavit. It's opposed to Hongo South. In compliance with the rules of this conference.
You got any problem?
24, sir.
21.
24. Supposed to Hongo South. In compliance with the rules of this court. We file a written address. We adopt it as our argument in support of our counter affidavit. Briefly, just to elaborate briefly, we want to refer this tribunal to Order 11. Of the Tax Appeal Rule 2021. Which is to the effect that this honorable tribunal can only grant a stay of proceedings if it is equitable, and preserves the rest pending appeal. circumstance in this case, there is no rest. Final judgment has not been given yet. We are in receipt of a further affidavit with the support of the motion. And the attached documents. The appellant has not been served. The appellant has not been served with record of proceedings. Not been served with the appellant brief.
Record of proceedings.
The document they attached, they said it's record of proceedings. Yes, yes.
Won't be fine.
Would not be said. The document is not even a certified true copy too. For us to say, okay, it has been filed, so it be also on us to point it out to the tribunal. Would not be said. This morning I called the office, the chairman's office, just to be double sure. Would not be said.
We don't have this before you are.
We don't have it. It's a bundle of documents. Oh, you know, when you say record of proceedings, it should be a voluminous document. We've not seen it. The appellant brief, we've not seen it.
Yeah, that now the records of appeal.
Yes, sir. Records of appeal. We've not been served. It's not enough to attach this. The first pages of all the documents when they are not even certified reports. On the federal record, it's a court of record.
I don't even know the new set.
They're not certified. Coming from the federal record. It's not from this tribunal. It's not.
What I'm saying, the record of appeal, what I'm saying is, because of proceedings, this is. I did have records of appeal.
On the face of their further affidavit, they made mention of the.
So that might have.
On the face of it, they made mention of which I am not aware. Yes. So if it has been entered by the rules of the tribunal, Federal High Court tax appeal rules, that is the law we are relying now because they've gone on appeal. We ought to have received it.
Yes.
Yeah.
We ought to have received it.
Yes.
And that rule was not cited anyway. So that means the
Your submission is right. That's the best.
Yes.
Not been served.
With the
No,
record of
sir.
the
Record of-
and the appellant brief.
Yes,
Yes, what again?
we urge this tribunal to dismiss this motion in its entirety. We are not asking for it.
No.
Yes, sir.
Narrator,
Okay. Yes, Mr. Chairman.
this area for the none.
You have the council on the other side.
Yes,
Yeah,
sir.
anything you want?
Yes, sir. Actually, I'm very surprised that we counsel is saying that he has not been served because we have mobilized the sheriff of the tribunal to serve of the court to serve the appellant brief and the records. However, the fact is before this honorable tribunal and documents have been put before this tribunal stating that we have filed.
Well, if your service, you can sort that out. Do you have any rejoinder on the issues, the arguments, submission of the counsel to the appellant? Did they cite any anyway?
No, Mr. Chairman. We would just like to state that we have filed and now the matter is before the appellate court.
You've made that one. That's it.
Has got here.
It's convenient.
This case is further adjourned to the 17th July 2026 for ruling on the application for 0%.
Yes. I apologize, I did not get the date.
17th July.
Friday, 17th.
Has got it. That's grateful.
Then, where's that? Where's this for our hearing?
No, for the file the motion.
Any other?
Yeah. So,
Okay, so it's going on hold.
We filed another motion.
Okay, so go on. Let's take 10 minutes.
Send this.
using of which starts with all there are the mutual potential between just okay, that's good. It is not. Joe, no, go ahead. I just want to all the time I not have chance to it's just usually outgoing. After the last time. It's not due to business. It's not due to this. What would they? You know, I did the revenue of it on that place. The revenue that is in the football. The revenue that is in the state. The renewal of the incorporation of that. Because of that, though Lagos State appealed that, so it's still applicable. But Lagos should actually do that. Then the feature that when you make mention of utility trust, it's not really a trust. It's responsibility towards the legal team, something from parts for CI. But no, but so for one week in touch with the 1 week consultation. Yeah, discussing, we're just talking like this and sad. No, I'm asking, I don't know, certain question you have maybe one for 80 of the meter. One makes the tax, the exemption, but what is happening, like, but not in one makes what consumption, one makes the consumption. One is about consumption, either a consumption or what other taxes is something that shows end users want to pay on this place. For example, agent that collects the agent that give it to the end users should want that you treat that payment. I don't know if it was what I'm saying. There was some poultry shop. Or this constitution was established logic and you have to add value to take value added tax from bottom to be income. You apply to be an agent, but you can work with after that we can if you are adding value to the taxes. It's the same user but there's also output tax. Yes, also we need for you to see okay, when you can buy the production from this price, I go to my person.
You keep water, just like you
Take
take water
water
from the tap.
from the tap or from because the value of added to travel that of the value. When you tell us what the end user pay for work, when we are calculating it as absolute terms, you don't right tax. What? It also are we to add to 2% time. Which the culture agriculture pastors instead on the time to not private knowledge that's the quality of ways to call class ordinary agricultural program. You see less than less. They need to fry it, they put it and package it into a container and you only pay it. What are they making favor crispy cheese? I don't know if you have added value to what it's big area. It's big area. We've added value to it only in favor crispy cheese. Now it's no longer it's not what chips. When we look at Bangladesh, less medical happen. So the value that you have added to the end user and value, and you have to store it. That's very important. So we find but then let's move with this. Just finish to you can't leave it. But there's a weakness on really income disclosures. As I was saying about the unity of both systems. Tell you that or you need just the next part to last. So it's mean the nutrition. Ordinary for the issues. So there's as good as so starting with the nations. We are really not blessed at what happened. And you are able to share it till you make it like, are you the only one? You have to try to follow that from the education. Oh, you didn't ask them, where are they first? What do they come to? Fast. These are the part of things, like all your plans are. So many of the things you had was wrong. Yeah. You didn't actually delve into this yet. I would change yesterday when to ransom. Okay. When I was even everything. And you also teach us a doctor, brilliant reputation, to break it down. What's so it's really advanced and lengthy. Maybe when they were sitting on the vehicle. It's the best models and the from more people. No, Tuesday, right? Tuesday night. You not take when is ABN session? ABN session. Everything is working now. For it to be a calling is working now.
No, if it's working, you should go be taking the direction.
Which one is working?
It's
We have that. For the week of the spirit of like not take it, it's a trap on something. We have the association. In Thursday, no. What do we have? No, you come and we come. You're welcome.
The price is almost at
The week of that, it's only the 16th. You know, also too far. Like the level of senior mayor. But if it's also because the election to be something and then some of it we don't touch it in classes. The level is really less than the number of like the particular question that was when the first year only pay is that's not nothing will work fast. So it's maybe you're working in the boundary of what state. Say for instance, you see action. What do you look for that? Focus things. Because you can't because some of your working with that part of that sound action and you be in focus things. But maybe you just also different things. You do don't really focus things. We don't comes on this. We play the quick. You should hear the zero. Hear the question when they are now change. They're like that's what they are needs to. And then they leave about 8%. They only want the process. You want one. It is not this process is if you live in a boundary or you live in local land use and you I live in the and work in a poor or is in that state, just a boundary between Nova and Asuko. Which where are you from? You're familiar with this thing. That's like how much you see. But if you're not someone to stand apart from one, somebody watching living with it, but usually put on cheaper. Design is a sort of processor. Is that you pay taxes, not actually towards the savings. But when people do the new tax and place your place. So here you stay. Also pay tax. I think that is here. So it's really happening for us. And you work. By that another one which we are looking at it. You work 8 to 5. How many hours? 9, 10 hours. 8 to 5, 9, 10 hours. Manage 9 for 24. So you stay out 15 hours. So you spend your 15 hours in your place where you're and then it generates your revenue. I used to be I'm going to many of them I think I said it was. Who do you pay first? Just that is not first. You have to go
I feel it's too much since we are doing it.
So why you there? Good morning. Thank you. Yes, I think it was your uniform. Okay, here we are. No problem.
So, no rush on.
Thank you so much.
I'm not student. So why you not happy?
Me, I'm not going. Me, I'm not student. Justice for me. Justice for me.
It's okay.
Equity sees as done, that which ought to be done.
I understand. And delay equity, bro.
Equity also aids the vigilant and not the ignorant. I'm very vigilant here.
Of course, you are vigilant and you also do your station.
You are not lawyers, so you don't understand the license.
Almost.
I don't know that CBI I can disappear now. Who is wearing black?
Nobody is wearing black.
He's wearing black.
I can make you stay.
No.
Where you going?
Wait to see someone that wants to be as you wish to be.
That one go.
I want to go to you. You refused.
I think you don't try.
You know, I'm black right now. I'm leaving this town by tomorrow morning. I'm out of here.
Yes, sir. Yeah.
You know,
I know. I went to this. Yeah, I'm coming. So we manage this.
Please, one of you should call that to that open it. Yes.
It's not going on.
Excuse me. I'm trying to understand the hearing, but I don't know who is on the side. I know there's an appellant and there is a respondent, but I don't know who is on the tax side of the taxpayer. Yeah.
All right, please. It's really at the end of it, there are some questions to ask. Later after the end. Just go ahead. Number 4 on the court list with appeal number T80/SSS/022/2025. Bayelsa State Board of Internal Revenue versus Westfield Energy.
Appearances.
With utmost respect, Mr. Chairman and members, my name is I.M. Benedict. I appear for the appellant.
May I this honorable tribunal? Anastasia Hubay. Attorney.
Yes, we can hear you. Respondent.
Mr. Chairman, is it better now? Can you hear me now?
Yes.
Okay. May it please this honorable tribunal. Anastasia Woye.
Anastasia.
Woye. Appearing with me is my learned colleague, Sylvester Innocent. Sylvester Innocent. Just the both of us. Our parents is for the respondent.
Okay.
Mr. Chairman, the matter was scheduled for hearing of a preliminary objection, and we declined permission of the tribunal. I'll call on my colleagues to take that.
Any party representative?
Sir?
Any party representative?
Yes. We have a representative of the company on the call, Omonike Ayele.
We can't see the person.
Omonike.
We can't see the person.
She's joining online.
But we can't see her.
Omonike, put on the camera.
Yes.
You don't know what the issue is, but Omonike is leading you.
If we can't see her, we can't record her. So.
Tell her to put on her camera.
Yes, she can hear us, I believe.
Let's go on. You say who is taking the patient?
Mr. Chairman, I think we can proceed.
I said, let's go on.
Yes. Mr. Chairman, I said we have honorable members of the tribunal. The matter is scheduled today for hearing of a preliminary objection.
Yes?
Yes, Mr. Chairman, Omonike's camera is on down. I don't know if you can see her. Omonike, please. Could you?
I heard her mentioning we've not filed any counter in respect of that.
Yes. What's her name?
Omonike Ayemi.
Omonike
Ayemi.
Designation.
Good afternoon, Honorable Chair.
Designation.
Legal associate officer.
Legal associate.
Officer for the respondent. My apologies. I was having network issues.
Yes, baby.
Yes.
Thank you.
There are two consistent applications before the tribunal. One is to strike out, the other one is to regularize.
There are two
consistent application before the court, pending application. One is the appeal to strike out. Ours is to regularize. They were served on the 7th.
One is
16th.
One is for striking out.
Yes.
Plus firing.
One to strike out was filed.
Pronounce it.
It was filed on the 19th of December, 2025. The one we filed on the 15th of June, 2026.
Your own is for what?
It's to regularize. It's a motion.
Huh?
Motion or notice for leave.
For me.
Yes, sir. We have read the ruling of the tribunal, so we thought it wise that we can bring this application.
You want fire 15 June.
Yes, it was served on them on the 15th of June.
Theirs was 19 December.
Yes, sir.
15 June 2026.
Yes, sir.
The one on 19 December.
Yes, we can serve. We've not responded.
We've not responded to the one on December 18th.
Looking at it, there's no counter.
Yes,
Thank you, Mr. Chairman. Yes. Mr. Chairman,
Are
the
you hearing
matter
me,
today. Yes,
Are
I
you
can
hearing
hear
me?
you, sir. I can hear him as well. So, Mr. Chairman.
You filed a motion on notice on the 15th of June. Have you been served?
Yes. Yes, so Mr. Chairman, we were served on Monday, but today's matter is scheduled for hearing of the preliminary objection and is listed on the course list.
You were served when?
We were served on Monday this week.
What date?
That's Monday, 15th June 2036, virtually.
That was 15th.
Yes,
That's indeed.
yes. There were 25.
Do you intend to oppose it?
Yes, Mr. Chairman, we're still within time to respond. So the application is not even before this court because we're still within time. I think we should move on with the matter for today.
And we intend to oppose it.
Yes,
We
we
intend to
do.
oppose it.
Yes, Mr. Chairman.
So you are still within time.
Yes, Mr. Chairman, we're still within time to respond.
How many days are you entitled?
In the absence of provision under the TAT rules, we have 7 days per the Federal High Court to respond.
So we can't pretend that we have not seen the application to amend.
Mr. Chairman,
Just let me finish.
want to draw?
Let me finish. We can't pretend that we have not seen the motion to amend. So if there are two contending applications, one to preserve and one to destroy, which one comes first?
Mr. Chairman, can I go ahead to respond now?
I'm asking you.
Respond, please.
Yes, so Mr. Chairman, it would please this honorable tribunal to know that this application is similar to the one on with respect to which ruling was entered on the 22nd of May 2026. And honorable members of the tribunal, considering that we're still within time to respond, and that today's date was scheduled and entered on the course list for the hearing of a preliminary objection, and relying on the case of Bang and Mohammed, a Supreme Court case delivered in 2008, we deem it right that today's matter be taken as stated on the course list. Below, the case cited is Pang. Pang is spelled P-A-N.
What's the authority? Can we? Oh, no. Can we pretend that there is no motion to amend?
The case cited said a course list is an agenda, is similar to an agenda of a meeting. And as such, any course.
Let's get the case. What's the case?
Citation is 2008. Pam versus Mohammed.
The name?
Pam, P-A-M, Pam. Versus Mohammed. Supreme Court decision 2008.
Yes.
16 Nigerian Law reports. That's 1112, 3112.
1112.
3112. 1112. One at page 84.
Two people are connected.
And that is Germany.
It's Germany.
Maybe one person.
What is the essence of this? This is that information.
Anastasia, can you hear us?
Yes, Mr. Chairman, I can hear you.
Yes, the case you just cited, what was the issue?
Mr. Chairman, in that case, party had attempted to surprise party on the other side by bringing to the attention of the court another motion being filed. And the court held that a trial court must obey the court's list and that no party must be taken by surprise.
Why surprise? What is the surprise?
Mr. Chairman, the intention of party on the other side is to arrest today's matter to prevent the hearing of a preliminary objection, which has since been filed since last year. And the application is similar to an application that this honorable tribunal has ruled upon. As frivolous as we deem the application to be.
So when there's an application to amend and one to kill, which one comes first? Which one takes precedence?
Sorry. Miss Honorable Members of Tribunal, the point we are making, because we've not responded to the application and we're still within our rights to respond, is that this matter was slated on the court's list for which we are being gathered today for the hearing of a preliminary objection.
Okay, Anastasia, let's do it this way. Can you hear me?
Yes, sir.
If we take your application and by chance your application succeeds, what becomes of the application to amend?
Mr. Chairman, the application Mr. Chairman, it could also go both ways. If an application doesn't succeed, this can also be heard. And Mr. Chairman, I'll give you.
Can you give me an answer? What if it succeeds? What becomes of the motion to amend?
Our preliminary objection is on the nature of the process before the court. It is not on their motion.
You are not answering my question.
The principle of hearing the other side, fairness. The principle of hearing, giving party fair opportunity. So,
Mr. Chairman, on the issue of giving parties fair opportunity, this matter, this particular application is the same application as the previous application that this tribunal has heard and determined.
Okay, let's.
And they are yet to respond to a preliminary objection.
Yes, since you don't want to answer the other question, let's ask this one. I asked the question before. If there are two containing applications, this motion to amend was filed on the 15th, and you confirm that you've been served.
Yes,
So,
Mr. Chairman.
it means that application to amend is in existence.
Before.
Yes,
It's
Mr.
before
Chairman.
this tribunal. It's before this tribunal.
Yes, Mr. Chairman.
There are two containing applications now. One to amend, one to cure.
So,
legally speaking,
Mr.
which of the applications takes precedence?
Mr. Chairman, I beg to differ because this application is not properly before the courts as we are still within time to respond. And this matter is slated.
How is it not proper before the tribunal?
Because all applications are not in. Our response is not before this court. So we cannot properly determine whether this application is one intended to save.
Well, the policy of this tribunal will always take the application to amend first.
Mr. Chairman, unless this matter would be adjourned for hearing of the application, otherwise I would move for a preliminary objection to be heard, since that is what this case is adjourned for, and there's a Supreme Case Authority on the point.
Mr. Anastasia, is it Mr. and Mrs.? Miss or Mrs.? Anastasia?
Miss.
The
Yes,
tribunal
sir.
has decided we will take the application to amend first before we take your appeal. So if you say you are within time to file your counter affidavit, we'll give a date.
Yes, we are within time, sir.
Yes, we'll adjust it to you for you to file your counter affidavit. We will take the application to amend before we take your appeal. Alternatively, if both parties agree, we can take the two together.
We can take the two together.
Yes, we prefer for it to be taken together.
So we'll adjourn the case. And you must respond to the
To save time, I also want the tribunal to take both motions together.
So we'll adjourn the case. You can take both together. So you can do this. What is? Let me see. Anastasia.
One moment, Mr. Chairman.
Are we taking it on the 16th?
Yes, 16th is convenient, sir.
16th of July.
Yes.
We'll take both applications together.
Yes, Mr. Chairman. That's it.
he said something that the person was not stating the law, the person was stating facts. Okay.
So he was sitting down. Okay. He was not stating the law. He was stating facts.
Points of law.
Yes.
Okay.
So I was like, since the person is stating facts, that means that fact is true, right? Facts are true. So what is the need for the law again since the person is already stating facts? That's just my question, sir.
When you are stating, what you meant is, here, facts. If you depose have you seen an affidavit before?
Yes, sir.
If you swear
Like if you went to the court to do declaration of birth.
Yes.
Yes. That is an affidavit. You see, they itemize it 1, 2, 3, and so on. Those are facts.
They are not law.
Those facts you are putting there, it doesn't mean they are true. Assuming somebody else brings something different to say that. For instance, if you depose there, you say, I was born on the 15th of June 2018. Somebody who knows exactly where one can come and say, denounce that and say, no, that thing you depose there is wrong, it's not correct. So you were not born on the 15th of June 2018. You were born on the 15th of June 2008. I don't know facts. The other person left facts. Then the other person now brought the other facts to counter what you deposed to. Those are still facts. They are different. Law is, you cannot, law is law. What is a feast? What has been decided? You may not be able to really understand the technicality involved. So when you are what it meant that the other person was setting fact, he filed an affidavit. The other person filed affidavit, he filed a counter affidavit. Or he filed a counter affidavit, the other person filed affidavit, he filed a counter. And then there was a further affidavit. So now, what he was saying is that the other person cannot give facts, cannot
testify on his own.
It's like giving evidence, testifying
on his own.
Based on that further affidavit, because he didn't file a further affidavit himself. Those are facts. So there was no, that's why we were saying, if you can give facts, then you can cite law to back it up.
To support it. Our very issue was that it was his own document he was speaking to, not his own.
For instance, if you say the law is that no accounting student from Uniben should come to the tribunal. Then I will cite a law. I say the case, so case that was decided. And I cite a case to back it up that no accounting students should come to the tribunal.
Or the orders and the rules of the tribunal.
Yes, or
no,
the rules.
We
have our rules here. You can say from the rules of this tribunal, it is stated that no accounting students should come here.
So you quote the section.
So that's why we say, what is the law? What are you citing to back what you have said? Yes. Now, if I say no accounting students should come here, okay, what law do I have to back it up? When I say no accounting students should come, that is fact. This is not law. So and I say, what is the law to back that up? To support that fact. You understand?
Yes, sir, I do.
So that's why I was saying the other person was talking facts, not law.
Thank you,
So
sir.
Mr. Bembe, you see that what you were saying.
You became a point. You're not the point of law. You're not the point of law you have referred to.
I'm happy that none of them referred to when you were refusing to sit down.
Another person.
Okay.
Yes, right.
There are two persons.
I asked one question before, but I later got the hints. Like I was asking, my name is Victoria Gakieno. So I asked one question before, during the 10 minutes break. So I later got a hint. Like I was trying to know who the taxpayer is and who the tax side of the tax authority. So I got a hint in this last one that he is from the tax authority and the virtual is the taxpayer. So I have another question. So Mr. Bembe stated in the first the one before this, the one before the hearing before this one, before the 10 minutes break, he stated something like 7 records of appeal.
Records of appeal.
Yes.
Okay.
And it was I can't remember her name. The woman. Yes, yes. No, yes. So she was now, she said something that she thought they had already served the records of appeal. So it's the records of appeal that I don't understand.
Okay. That case, what happens is that a decision has been taken by the tribunal. When a decision is taken, there are two parties. Decision is taken. One party that is not satisfied with that decision can appeal to the Federal High Court. So in that case, those people you saw on the screen, they have appealed to the Federal High Court. So now they are bringing an application that the case here should not go on, should wait until that appeal is decided. So now what happens is that here, the secretariat here, what they will compile all the records. The record means all the documents that have been filed here. All the documents that have been filed here in that case from both parties. And the decision of that they are appealing against, they will compile everything together. It will be recorded. It will be like it. And they'll bind it into that is record of appeal. All the records of appeal. I think the record of proceedings. It should be records of appeal. So you understand, they compile it. That is what they will forward to the Federal High Court. So he was saying that he has not been served with those documents.
Thank you, sir.
Yes. So you now know the tax authority and taxpayer.
Yes.
And you are also a taxpayer.
Yes, I am.
Do you pay tax?
I pay indirect tax.
Where do you work?
Which one is indirect tax?
Where you work?
No, she's indirect Which indirect tax are you paying?
All those bad.
I pay VAT.
But where?
Anything she buy. Okay, go on. Let's hear you.
How do you pay your VAT?
Oh, on like yesterday, I want to give a scenario. So yesterday I got a bag of pure water. So 7.5, it was 550 naira for the bag of pure water. So 7.5 out of that bag, like 1.5% of the 550 naira is going to the government.
You bought it from a supermarket?
Yes, this is.
Or the roadside?
No, in school. I wasn't given any invoice.
So, wait now, the 500 naira, 7.5% now, 500 naira is how much? You want to use your calculator? Okay, 10% of 500 is how much?
50 naira.
So 7.5% is good. Yes. Some people do, they go into the banking hall, as if they want to transact. They go and sit there.
How long would they do that?
Kids,
How many
no,
banks
I'm
would
not
they
saying
for
from
banks?
yeah. They go in there
I
and
use their
data. I use their data. They go into these big hotels. They go and sit there.
Okay, for Zimity.
Use
For
their
how
Wi-Fi.
many big hotels?
Yeah,
have
for
those facilities
airtime,
that you
for
can access
airtime, the consumer cannot avoid paying bills because it's already included in your airtime. So it
Exactly.
fix
If you buy airtime, you automatically pay back.
it's already there. So what you are paying for, maybe you are buying airtime of 500. I don't know, you buy recharge card.